Good morning and welcome to Hot Seat. My guest this morning, Stephen Greetham, Esquire, Special Counsel to Chickasaw Nation. Good to see you, sir.
Good morning, sir. Good to see you.
It's been a while since you've been on Hot Seat.
It has been.
But we're still talking about the same thing, sort of.
The more things change.
All right. Can I quote my favorite Missouri haberdasher who later became President of the United States?
Absolutely.
Harry Truman once said, "The only thing we don't know is the history we haven't read yet." So let's start with the conflict between the governor and the tribal nations. But let's go all the way back to the beginning as to setting the stage as to why that there's a conflict.
And that's a broad question. When Oklahoma was formed as a state, there were already dozens of tribes on the ground here, each of whom had treaties with the United States, each of whom were promised permanent homelands in what was then Indian Territory, then joined by Oklahoma Territory. The process of statehood was a messy process, and many questions were left unanswered or answered only by assumptions. We've known about a lot of these unanswered questions for generations, and over time, different questions percolate up, and every time they do, the tribal governments and the Oklahoma state government have the chance, the opportunity, the challenge to figure out how to proceed, how to answer those questions. In Oklahoma, really since the 1970s, the first wave of dealing with some of those questions as the tribes were reorganizing themselves, getting out into economic development, so on and so forth, was litigation. And there was quite a bit of litigation between the state and the tribes, primarily over taxation issues and other matters of economic development and governance. And in 1991, actually on tobacco issues, the U.S. Supreme Court, to my eyes, got a little tired of the number of times Oklahoma kept bringing these cases back to the Supreme Court to referee, and it's ruled in the case, Citizen Potawatomi versus Oklahoma Tax Commission, gave its legal holding, and then basically said, guys, you can also sit down and figure this out. You can sit down and negotiate agreements and bind yourselves to intergovernmental respect and rules of conduct. Within a year of that ruling, we had our first tobacco compacts, and that really started the second wave of tribal-state relations here in Oklahoma. Today, there's over 900 intergovernmental agreements between the state of Oklahoma and various tribes. The core ones, the ones folks most hear about, gaming compact, tobacco compact, motor fuels, more recently hunting and fishing license tags, deal with complex issues of substantive disagreements between sovereigns, but the parties have been able to come together, make meaningful compromise that respect each other's positions, and figure out ways to work together for everyone's benefit.
Let me just go back just a little bit farther, near history, okay, recent history. Governors Fallon, Governors Henry, Governors Keating. There did not seem to be, even though disagreements, it didn't seem to reach this level of passion.
I think that's a true statement. I look back on the Fallon administration. During Governor Fallon's time in office, we had disagreements, obviously. We had the Chickasaw, Choctaw, Oklahoma City, State of Oklahoma water fight. But we were able to, within 5 or 6 years, come to terms, come to agreement, go to Congress together, and move forward. And that's what we've been doing now since 2016. During her time in office, we renegotiated over a dozen tobacco compacts. The hunting and fishing compacts were done during her time in office. The 3 license tag compacts done in her time in office. In the current administration, it's been an entirely different situation. There have been no new tribal state agreements formed other than a couple that have been struck down by the Oklahoma Supreme Court as being done by the illegal acts of the Oklahoma governor. And we're left in a position now where we're seeing a lot of these compacts that were built over generations go away. Already, since Governor Stitt came into office, 6 tribal tobacco compacts have expired without comment. 5 of those tribes weren't even McGirt tribes, so that the issues that he's bringing to the table now on those issues weren't part of why those expired. End of this year, we're looking at 15 more tobacco compacts expiring. Governor Stitt walked away from the hunting and fishing pacts with Cherokee and Choctaw. It's a different tenor. It doesn't have to be this way. Governor Antebbe regularly says to me, you wake up every day in a new day. And the way I interpret that is you don't forget what happened the day before, but go into that new day with some hope. And we can always kind of restart the relationship. We can always move forward. But it takes meaningful respect and a commitment to cooperation and actually hearing each other. As a tribal advocate, I think one of the most difficult things to try to figure out how to manage is right now the conversation is dominated by talking past each other. Since the Tobacco Compact issues arose, Governor Stitt has met with the Chickasaw Nation, his team has met with the Chickasaw Nation representatives once. I'm unaware of any other meeting having occurred between the governor and any other tribes. There have been numerous press conferences. There have been numerous press releases on both sides. It's not what we need. What we've seen recently in the Oklahoma legislature is their intervention and offering some leadership on the state side of the discussion to just give more time for folks to sit down and figure out how we want to proceed from where we are.
Let me dive a little bit into that to interrupt for just a moment,
Sure.
which is this last couple of weeks we've seen legislative overrides of compact. There's multiple compacts. Sometimes I think the media doesn't differentiate well what they are. What has just happened at the state legislature and then a subsequent desire by the governor to sue the legislative leadership, of which it's all the same party, Republican Party. Break that down for us as what that all means.
So I mentioned following the U.S. Supreme Court ruling in the Citizen Potawatomi versus Oklahoma Tax Commission case back in 1991, folks came together and figured out a compact. And this is important. The framework and the policy on the state side of that compact is in statute. It was legislative leadership that provided the direction and wherewithal for the state to organize itself and engage with tribes and enter durable tax agreements. And they deal with the taxation on tobacco products. In that statute, the legislature crafted the policy and said what the consequence of an agreement between the tribes and the state would be. It also said the Oklahoma governor is authorized to go out and negotiate with tribes. What we're seeing right now is less a tribal state disagreement and more of a legislative executive disagreement within state government. The governor has taken the position that he has the exclusive authority to work with tribes on these issues. And the legislature has said, no, we've authorized you, but we also have a role to play in setting the policy for the state. And that's
Something
true
Speaker
statement.
McCall was making.
Yeah.
The point he was trying to make was you don't do it absent the legislature,
Yeah.
these steps. So this is, the governor is, I don't mix these topics up, but also there's going to be some subsequent litigation or request for the Supreme Court to get involved. As far as the legislative overrides are concerned, that puts the agreement or the ability to negotiate agreement for another year.
Yeah.
Correct?
Yes.
Will that get done?
I'm hopeful. The tribes are already talking to each other about a kind of a unified position on those issues. I can speak for Chickasaw on this. Governor Stitt has focused on this issue of trust and restricted lands versus reservation as a whole. Weeks ago, we proposed an approach to the governor to manage those issues. And we premised our approach on existing state statutes and existing federal law, but agreed to a compact jurisdiction that satisfies his goals of trust and restricted lands without the tribes being forced to redefine the concept of Indian country, which is controlled by federal law anyway.
The governor's point was that the tribes are trying to turn eastern Oklahoma into a reservation.
Honestly, I don't know what to do with statements like that. The tribes aren't doing anything other than providing for their citizens and trying to follow the law. He's not going to turn Oklahoma into a reservation. The tribes have reservations. That's a matter of federal law. And this gets to an important point. Just like in the gaming fight several years ago, the tribes have been very principled in grounding their positions in the law as it is and proceeding from there, not railing against the law and demanding that we give up what the law provides for us. By working from a foundation grounded in the law, we can then identify what our challenges are, what the policies are we need to work on, and that's what a negotiation turns into. The public statements from Governor Stitt, I don't know what to do with, and I tend to just kind of tune them out as more of position as opposed to analysis on these issues. But let me say categorically, when he says, anytime he characterizes what the tribes are doing, the tribes' goals, like what the tribes' intents are, I don't know what he's basing his conclusions on. The tribes have done nothing but argue within the parameters of the law and continue to be a tremendous asset and resource for the benefit of Oklahomans throughout the state. When you look at tribes as far as their contributions to healthcare, transportation, education, so on and so forth, tribes make Oklahoma better. And I think the tribes are waiting for leadership from the state that recognizes that and is willing to engage, understanding them as governments and understanding them as partners.
Let me turn to Hooper and McGirt. So we've been talking about that for some time. There is the statement from the governor that Tulsa cannot write a speeding ticket. It has to do with the citizen getting a ticket in Tulsa area. This has to do, and that's Hooper, Mr. Hooper. And then there's the McGirt ruling. So much news about that. Help us understand out of that fog what's going on there.
Some nonsense is what's going on out of that. City of Tulsa has a cross-deputation agreement with both Muskogee Creek and Cherokee Nation. When City of Tulsa issues a citation to a citizen of a tribe, it lacks jurisdiction not to issue the ticket, but to enforce it. That's why you have a cross-deputation agreement.
Tulsa can write speeding tickets.
Yes. What they do then is if they're within the Muskogee Creek Reservation, they refer that ticket to the tribe. If they're within Cherokee, they refer that ticket to the Cherokee Nation. And then the tribe proceeds to enforce the ticket. And what's interesting, Chickasaw does this, Choctaw does this, Cherokee does this, I'm not sure about Muskogee Creek. After the ticket is enforced and the tribe receives the payment or there's some payment made, those dollars then go back to the jurisdiction that issued the citation. So within the Chickasaw Nation, we have cross-deputation agreements with 76 different jurisdictions within our boundaries. Virtually every police officer who is on the ground in the Chickasaw Nation has the authorization as a federal officer, tribal officer, and or state officer. They can deal with whatever the situation is on the ground. What happens is, if the state lacks jurisdiction to enforce, it goes to the tribe. And we see that, for example, just this past week. The OSBI brought charges against a sheriff deputy within the Cleveland County the Sheriff's Office. They referred the charges over to the Chickasaw Nation, and as well as the Eastern District, the U.S. Attorney's Office. So this notion that if the state can't prosecute, then folks are getting away with murder is nonsense. It's simply a requirement that folks work together to ensure things go to the right prosecuting authority. One more stat or number to throw at you, and this is one of my favorites. Chickasaw Light Horse, about 2/3 of the cases they investigate aren't prosecuted by tribal prosecutors, they're prosecuted by local district attorneys, because tribal cops are arresting and building cases that are then brought into state court by state prosecutors. By the same token, a full 2/3 of the cases our prosecutors at Chickasaw Nation are bringing in tribal courts are referred to us by local police, not Chickasaw Light Horse, but local police who have cross-deputation agreements. Chickasaw Nation handles about 2,500 criminal prosecutions a year. And that benefits from the substantial and robust level of intergovernmental cooperation we have on the ground. So when I hear this, and I'll just call it what it is, fear-mongering, that if the state can't do it, no one can, that's just factually not true. And I know the Chickasaw Nation is deeply appreciative of the partnership with the local agencies. I know the other tribes that work closely with the local agencies are also appreciative of that as well. Everyone has a single mission: keep folks safe. No one disagrees with that. We just have to work together to get it done.
Any other issues with Hooper McGirt that we're going to be seeing come forward in the next year or two?
The city of Tulsa has indicated it wants to go to the U.S. Supreme Court on Hooper. That is a choice. Consistently over the past 5 years, Oklahoma in general has reached for the courts as opposed to the phone. The opportunity to work together always remains, but so long as folks keep running back to the U.S. Supreme Court, all constituents will remain polarized, and it obscures what the real policy issues are we can be working on. I want to be clear on this. We don't have a real disagreement with folks as long as we start with the law. If folks want to refuse to recognize the law, refuse the reality of the McGirt ruling, refuse the reality of tribal reservations, that makes it hard to have a conversation. Let's talk about what the consequence of a reservation is. Let's talk about who's best suited to play what role. Let's do it respectfully. And let's do it in a way that aims not at some kind of zero-sum game, winner-loser approach on it, but that moves the ball forward. We have done that so many times here in Oklahoma, and it's time to return to that tradition of working these problems out.
All right, let me go next to gambling agreements. A few years ago, the governor did compacts with 4 tribes, I believe was the number. Mm-hmm. There's been lawsuits over that. I believe the Chickasaws, Choctaws, some others, Cherokees were involved in a lawsuit.
Potawatomi as well.
And this week, or the last month or so, the Attorney General and leadership, I believe, have agreed with him, which basically he wants to enjoin or represent the state's interest, not the governor's interest. He's made that point. The state's interest, not the governor's, and get these settled expeditiously. Help us understand what that's about.
Well, it's interesting. If you cast yourself back to 2020, we got a federal court ruling that the model compact renewed. And we got a ruling out of the Oklahoma Supreme Court that those gaming agreements Governor Stitt signed, the first 2 with Comanche and Otoe, Missouri, were invalid, that the governor lacked the authority to do what he did. So those were struck down as a matter of state law.
Some federal said it was okay, correct?
Well, we haven't gotten to that point yet. You also had an Oklahoma Attorney General who said it's illegal. That's all a state law question. The Oklahoma administration proceeded then, notwithstanding what was happening here on the ground, to go to the feds and seek federal approval of those agreements under the Indian Gaming
Basically
Regulatory
ignoring
Act.
what had happened on the state level.
Yes.
Okay.
And the Indian Gaming Regulatory Act has a odd little provision that the Department of Interior can essentially play the role of Pontius Pilate and say, I wash my hands of this. I'm just going to allow this to go into effect. Whatever happens, happens. And that's what they did. Governor Stitt then took the position that the federal action made his agreements valid. That's wrong. And 4 tribes who were injured by that action went to federal court for the simple purpose of having a court say what the Department of Interior did was unlawful under the Indian Gaming Regulatory Act. The Indian Gaming Regulatory Act requires that there fundamentally be a validly entered compact. It wasn't. And the Department of Interior knew they were not validly entered at the time they were conducting their evaluation. We filed that lawsuit back in 2020, I believe. We're now in 2023. The Oklahoma has taken the position in the litigation so far that the rulings of the state court didn't matter, that state law doesn't matter to this question, and that the Oklahoma's governor's conduct was lawful, notwithstanding state law. The new Attorney General Drummond, has indicated his intent at the request of the House and the Senate to come into the lawsuit. Governor Stitt, it's perfectly valid for him to continue to have his own lawyers in the case, but the Attorney General is going to speak for the state of Oklahoma. As a tribal advocate, one of the things I am deeply appreciative of is for there to be an Oklahoma Attorney General who shares the same perspective. We have to start from the law. Anyone who thinks that Attorney General Drummond is not a fierce advocate for Oklahoma sovereignty and Oklahoma interests and rights isn't paying attention. What he's doing is let's ground our discussions in law, because that's going to give us our most stable product, whatever we do. If we make stuff up out of whole cloth, it's going to be worth the paper it's written on. So he's coming into this and he's insisting that this litigation be grounded in what state law has already decided. I don't know what the consequence of that ultimately will be. The core fight is between the plaintiff tribes and the Department of the Interior, but I fully expect we're now going to have Oklahoma's position shift to be, yep, those agreements were invalid at the time that they were submitted to the Department of Interior. My hope is it brings a quick close to the action. I'm going to anticipate one more question. What happens to Comanche and Otoe, Missouri, if that happens? Well, those agreements they signed have already been held to be invalid under state law. they're still parties to the model compact, so they can still conduct gaming. That's not really the issue. The issue is whether we're doing so in accordance with law or if we're just making stuff up as we go along.
The governor's folks are contending that he's not getting the right representation, that there's a conflict, and that legal ethics would prohibit the Attorney General from representing the state in this. Your thoughts?
I'm going to use the word again, nonsense. Look at the very first line of the answer that Governor Stitt's legal team filed in this lawsuit. The very first line is, J. Kevin Stitt, Governor of the state of Oklahoma, answers the complaint as the state of Oklahoma, which is the real party in interest. The governor is not a party in interest in this case. He is the governor. Oklahoma is the party in interest. And state statute makes the Attorney General the chief legal officer of the state of Oklahoma. I think it would be unfortunate for another distraction, a power battle on the state side of the table here. We need to put all this stuff behind us, and we need to figure out a way to identify real issues, decide them based on the law and real facts, and move forward. It's worked well for Oklahomans in the past, and it can still do that, but we got to commit to it.
At this moment, who is going to be considering the governor's assertion that the Attorney General shouldn't do this? And how quickly will it be resolved?
So far, to my knowledge, and I might be wrong on this, that position's only been stated in a letter from General Counsel for the Oklahoma governor addressed to the Speaker and the Pro Tem. I know it's been reported on in the media, but I'm unaware of the Oklahoma governor having made any filing in the federal case. So right now, you have the Attorney General entered as counsel for the state of Oklahoma. No one has contested that. So we'll go from there.
Last couple of questions. There are folks who are asserting that all of this is keeping Oklahoma from moving forward on sports betting. It's a ginormous, that's a new word, a gigantic source of revenue for a lot of states around the nation. It's coming big time, right? Mm-hmm. They're saying all of this kerfuffle is keeping us from moving forward on that. So what is the situation there?
I leave sportsbook to the side. I think you can make that statement with respect to any number of issues. When I look at what the state, local governments, and the tribes were able to accomplish during the pandemic, the tribes were fundamental in trying to keep people safe here in Oklahoma. When I look at what's happening in law enforcement, the tribes are fundamental to keeping people safe on the streets. When you look at economic development, the tribes are probably the best partners the state of Oklahoma could ever look for. And the inability for folks to kind of see past this notion that tribes represent an existential crisis for the state, get past that. There's an opportunity for the state and the tribes to work together to make sure that our gaming market keeps pace with our neighbors. A few years ago, 2018, again, during the Fallon administration, one of the limitations that was imposed in the model compact is tribes couldn't conduct certain forms of table games. We did the economic analyses. They could in Shreveport, Louisiana. They could in Las Vegas. And we saw patrons who were desiring just a fuller spectrum of gaming products opting for other markets. So we were seeing a decline in our patronage. When the tribes see a decline in our patronage, that impacts the revenue share that the state gets. So there's common interest there. We sat down, the state enacted a supplemental compact offer, again, through the legislature. And many of the tribes then accepted that, and we were able to keep pace with the market. Same thing with sportsbook. We need to sit down and figure out how to do another gaming compact supplement that would allow tribes to have an additional gaming offering that was consistent with the law and benefited both sides, the tribal and state side of the equation. What's interesting, and this is our own economic analysis of this, the money is less in sportsbook itself, and it's more in the kind of incidental lift that by having the fuller spectrum of options available to folks come in, maybe one of the partners in a relationship is a gambler, one of them likes to go to shows, maybe one of them likes one game, the other likes the other game. It's a broader entertainment experience, and it's better for tourism here in Oklahoma. I'm going to throw one more plug in. I can understand folks having different ethical positions on gaming. Totally understand that. But what's inarguable is the vast majority of dollars that tribes bring into Oklahoma's economy through gaming are coming in from other states. that grows the economy. And what's also inarguable is that tribes tend to invest those dollars locally and in the rural parts of the state that otherwise don't see the same kind of economic development opportunities. Every study concludes the same thing. And the gaming compact that tribes have with the state of Oklahoma is demonstrably the most lucrative gaming compact any state has with any tribes anywhere in the country under the Indian Gaming Regulatory Act. So this notion that somehow this is not something that benefits everyone is just wrong. And we need to move past that. And we need to figure out how do we keep pace with the national market on this stuff and continue to lead and benefit all the parties.
All right, I think we've covered who, what, why, how, but I want to get to when for my last question. Speaker McCall said the other day he hoped that the governor and the tribes could get the tobacco compact thing done before the end of his 6th year in office. We just talked about sports betting. When do you think we can see a resolution to all of these issues?
One of my favorite questions. Unfortunately, I don't have a crystal ball, but what I can say is, working for the Chickasaw Nation, there is not a table with reasonable people around it willing to work towards solutions that the Chickasaw Nation will not join. When I talk to other tribal attorneys, folks want a solution to these issues. So the will is there. The solutions are there. I told you, the biggest issue that Governor Stitt has put forward in the middle of the legislative process was this notion of trust and restricted lands. That's solvable. We can figure out how to work on that. What it's going to require, though, is mutual respect, talking to each other, and really deepening the relationship in a manner that has not happened in the past 5 years. So, my friend Sarah Hill, the Attorney General at Cherokee Nation, likes to say, even St. Paul was once Saul of Tarsus, and he had his road to Damascus moment. Every day we wake up in a new day, and I think we've got to engage, hopefully, and look toward the solutions as opposed to what divides us.
Stephen Greetham is Special Counsel to the Chickasaw Nation and Greetham Law PLLC. Good to see you, sir.
Good to see you, sir.
Thanks for being here.
Right on.
Thanks for watching Hot Seat. See this on news9.com/yourvotecounts and news6/yourvotecounts. And also follow me on Twitter, LinkedIn, Threads, and Facebook @Mitchell Talks.